Hey everyone, welcome to another edition of The Bullet. My name is Paul Lathrop. I'm the Deputy Director of New Media for the Second Amendment Foundation. Joining me today, as he does every other Friday for Legal Friday, is Alex Ooley. Alex is not only the host of the Forge of Freedom podcast, he's also an attorney in Southern Indiana. Alex, thanks for coming along today, man.
Great to be with you, Paul.
Let's start today. Well, a couple things to start off today. First of all, I wasn't able to get. If you normally watch us on Rumble, I'll try to get this up on a later basis. Right now, as we speak, Rumble is down. I wasn't able to get the show up live, but if you're watching us anywhere else, the show should be coming at you live. You can comment on the live video if you're watching on YouTube or on the Facebook Polite Society podcast page. We'll get those comments. We'll get them up on the air, discuss them as time allows. Secondly is Happy National Random Drug Test Day. Of course, yesterday was 420. A lot of people enjoy certain illegal on the federal level substances celebrated yesterday and went to work today, and guess what? So
it doesn't seem so random the day after 420, does it?
It really doesn't, but it is what it is. Alex, you and I pre-show, I want to get into this. You and I pre-show had a little bit of a discussion. Both of us are friends with Rebecca Schmoy, and you actually got to see her last weekend down at the NRA annual meetings. She posted up to Facebook today that the governor of Kansas signed a bill that eliminated the $100 fee that you had to pay to the state for a Kansas carry license. Now it's only, I believe, a $32.50 fee for a license, and that goes to the local sheriff's department. And that's a great step forward. There are a lot of states, my state, South Dakota included, and depending on the license, your state of Indiana, that don't have fees at all. And even though you're a constitutional carry state, I'm in a constitutional carry state. I believe we would both say if you can get a permit, do simply for reciprocity purposes, right?
Yeah, exactly. Obviously, I don't think you should have to get a license to exercise your right to keep and bear arms, because let's face it, if you have to get a license and ask permission to exercise a right, it's not being treated like a right, it's being treated like a privilege. And it's clear from the history of our country and from the Supreme Court, now the more recent Supreme Court precedent in Bruin, that the right to keep and bear arms is not a second-class right. It's a right just like the right to free speech and to exercise religion, and the right to be free from unreasonable search and seizure, and it should be treated like a right on equal footing with those. So to have to pay to get that right back just flies in the face of everything we know about rights. So that's
Absolutely.
A great step forward in Kansas.
It absolutely is. Yeah, and the one I often use is you don't have to go through college and get a degree in computer science to exercise your First Amendment right to free speech on the internet. You don't have to get a degree in English language. You don't have to pay for a license to go out and campaign for your favorite, for somebody you support for a local office. None of that is required in the free speech arena. You don't have to have a special permit to go to a church that you want to go to. Whereas, that's not the case with the Second Amendment in a lot of states.
No, that's a great point, Paul, and I'm glad that I think it's 27 states now with the recent news from Nebraska that do not require a license to keep and bear arms. So that's great news, and I'm glad that Kansas, which is also a permitless carry state or constitutional carry state, has removed the fee to obtain a license, at least the $100 fee to the Attorney General's office. So that's a great step in the right direction. Indiana followed a similar path. We had a 5-year license and a lifetime license. Unfortunately, we do have a lot of Republicans in the legislature here, but many of them are Republicans in name only, or what we often call rhinos.
Mm-hmm.
and we had to get to permitless carry incrementally. We removed the fee for the 5-year license, and then subsequently removed the fee for the lifetime license. And all of a sudden, when there was no revenue to be made from those licenses, it was easier to get to permitless carry. So I'm glad to see other states moving in the same direction.
Well, and that was, if I'm remembering right, that was one of the big stumbling blocks for a couple of years for permitless carry in Indiana is, well, what's going to happen when these funds from these permits no longer come in? So you had to get there by saying, look, we're not getting any fees anymore and we're doing just fine, right?
Right. And the legislature made provisions to offset those budgetary concerns. So that was no longer a problem by the time that permitless carry was being considered. Nevertheless, Republicans killed the permitless carry bill behind closed doors without a vote so that they could maintain their NRA rating without bringing the bill to a public vote. They killed it in 2021 and then finally passed it by the skin of its teeth in 2022. So thankfully, we had some great advocates in the legislature and otherwise that promoted the bill and spoke on behalf of the bill and really pushed it through.
Well, and just as every other state that has gotten constitutional carry, Indiana has not seen blood running in the streets. If anything, and we're having a totally off the cuff discussion. Alex has done no research on this, nor have I. But I'm suspecting, Alex, that if anything, crime statistics are trending down in Indiana since constitutional carry, right?
That's right. At least there's been no effect. If anything, it looks like it's trending downward. There was a recent article in Fox 59 where someone with the Indiana State Police, and I'm blanking on his name off the top of my head, but he wanted to attribute an increase in certain crimes in Indianapolis with the passage of permitless carry, and then they cited to some incidents that had occurred, and it had nothing to do with a license whatsoever. So it had nothing to do with permitless carry. So it was clearly just a hit job on permitless carry and an attempt to paint the passage of permitless carry as a step toward more crime, when in fact the truth is the opposite, that there has been less crime after the passage of permitless carry.
And there's been, I can say for certain, in South Dakota, there's been absolutely zero effect on crime because we weren't a huge crime state anyway. We're mostly very rural. And there's been negligible, if any, impact on crime in South Dakota in the 5 years we've now had permitless carry. And I would suspect that's the same over most constitutional carry states. But let's go ahead and we've got some stories I wanted to get in today. First one off of BloombergLaw.com, which to me is an ironic website name because Bloomberg and law together, I don't know. Anyway, they did have a story up today that the District of Columbia's large capacity magazine ban is constitutional. District Court's large capacity magazine ban survived a preliminary constitutional challenge in federal court on Thursday. Judge Rudolph Contreras of the U.S. District Court for the District of Columbia said that large capacity magazines implicate unprecedented societal concerns and are the object of dramatic technological changes warranting a public safety response. There's a lot more to the article, but Alex, it sounds to me like this judge is doing exactly what Judge Thomas said you cannot do in the Bruin decision. He was talking about a two-step process. Judge Thomas was about a two-step decision-making process, and he says that's just one step too many. This judge put that step back in, is what it sounds like to me.
Yeah, that's exactly right. This decision flies in the face of the Bruin decision and the instructions from the court in that case, which said that if a law burdens the Second Amendment right to keep and bear arms, which we know from Heller is an individual right, then we look to the text, history, and tradition, and are there historical analogs of similar gun regulation? And We don't get to any interest balancing. We don't ask whether or not there is some social benefit to the proposed regulation or law. Uh, that benefit, that balancing was done at the time that the Second Amendment was ratified. So that's where it ends. When the Second Amendment was adopted, what was the meaning then, and what sorts of firearms regulations would have been supported based on that understanding at the time the Second Amendment was adopted. So we don't get into this balancing test considering whether or not particular laws address societal concerns or address certain public safety issues. That those concerns are by definition balancing concerns, interest balancing concerns. We don't balance the right to keep and bear arms with those societal concerns. If they want to repeal the Second Amendment, there is a method to do that. But until that happens, we have to follow the Second Amendment and the meaning of the Second Amendment that was intended when it was adopted.
There have been in the last 90 years ago. Is the last time I can think of that an amendment to the Constitution was repealed. That was when the 21st Amendment repealed the 18th Amendment, which was the amendment where alcohol was illegal throughout the United States. There is a way to do it. It has been done before. It's almost impossible, but there is a way.
Right, right. And thankfully, and this is, I like to point out in this kind of discussion, that's the importance of state constitutional provisions protecting the right to keep and bear arms, because even if the Second Amendment, and I don't see this happening anytime soon, but even if the Second Amendment is removed from the Constitution or the Bill of Rights, we still have state constitutional provisions that would protect our right to keep and bear arms. And that's why state laws, state level advocacy is so important, because you want to make sure you have those provisions in place to protect your rights, even if you can't rely on the federal government to do so.
Absolutely. Let me get to a comment here real quick. George Geller, checking in from the YouTube side, says, okay then, no more crime in D.C. because they get that magazine limit law to live for a little while longer. Yeah, and again, of course, D.C. is a very crime-ridden city. I don't expect crime maybe to keep going up simply because of the liberal, and I'm going to go ahead and say liberal because it is liberal prosecutors. Everybody in charge of the entire city is very soft on crime and letting criminals out with sometimes no bail at all, sometimes short sentences. But if there isn't responsibility for what you do, you're going to do whatever you want. And if that's robbing and killing people, it's robbing and killing people.
Yeah, that's a good point. And the other thing I want to point out, too, about this so-called large capacity magazine ban, I don't have the language in front of me from the opinion exactly, but the opinion pointed to these magazines being most useful for military purposes. And again, that goes to sort of the interest balancing test and how useful is the right really. But that's not what we're looking at. And we know from Heller and was affirmed in Bruin that we look to those arms that are protected under the Second Amendment are those arms that are commonly used for lawful purposes. And the only arms that were historically prohibited were those arms that were dangerous and unusual. Not dangerous or unusual, dangerous and unusual. And these magazines that they're talking about are not unusual at all. They are extremely common. They are sold frequently, most of the time with the most popular rifle in America, the AR-15. So certainly these arms, not just firearms, but it's the right to keep and bear arms, and that includes magazines, are protected under the common use test, which we are familiar with from Heller and Bruin.
Well, and I believe it was Massachusetts that lost a court case on Second Amendment grounds. They had previously said tasers were illegal, and and correct me if I'm wrong, if you're familiar with the case more than I am. I'm just relying on a cracked memory here. But the Supreme Court said, look, these are common use. And look, what's more common, a 30 round standard capacity AR mag or a taser? I've got a lot of 30 round mags here in Casa Lathrop. I don't have a taser. I would think that 30 round magazines are a lot more common than a taser. More, I guess where I'm going with that is just more ammunition, so to speak, to say this is going to fall in the future.
Yeah, that's right. And you're referring, I think, to the Caetano case, which involves stun guns. And I think I don't remember the numbers off the top of my head, but I think that there were something like 200,000 stun guns in possession of private citizens nationwide, and that was enough that the court considered stun guns to be in common use. So I don't know what the number is for these large capacity magazines, but it's certainly much more than 200,000 stun guns. So I don't think there's much dispute from the anti-gun side that these are arms in common use, but they're saying that somehow the historical precedent supports the prohibition of dangerous and unusual arms. So they're saying that basically these are so dangerous that we have a reason to prohibit them. But that's just clearly not supported by the historical precedent.
Let's move on to our next one, and this one ties into what we were just talking about too. I got this one off CNN.com. Anti-domestic violence and gun groups unite to urge Supreme Court to reverse domestic violence ruling. Making a rare combination of resources, supporters of gun regulations and anti-domestic violence groups joined Thursday to urge the Supreme Court to reverse a federal appeals court opinion they say will make it easier for domestic abusers to obtain firearms. The groups say the High Court needs to step in now because lower courts are relying on one of the Supreme Court's decisions on the Second Amendment from last term to reconsider thousands of firearms rules, excuse me, including a federal law that bars an individual subject to a domestic violence restraining order from possessing a firearm. The Biden administration is appealing the ruling, and 11 groups are throwing their weight behind the government's request. This is where I found it interesting. The next paragraph, under normal circumstances, once the High Court issues a landmark opinion, it rejects follow-on cases so the issues can percolate in the lower courts. This Second Amendment case, they write, however, may be different. Last year's New York State Rifle and Pistol Association versus Bruin was the broadest expansion of gun rights in a decade and changed how lower courts must look at Second Amendment cases going forward. Alex, do you? I want to. I'm just asking as a common person to a lawyer. Is it true that once the Supreme Court issues something as big as Bruin, they generally don't take cases like that for quite a while?
It depends. So they will generally take cases of particular public importance or where there's disagreement among the circuits, and we're starting to see a lot of that. So there has been some percolation among the federal district courts and circuit courts, and there's already disagreement among those courts with respect to various issues, with respect to age restrictions for 18 to 20-year-olds, with respect to magazine capacity bans, with respect to assault rifles, so-called assault rifles. So we're starting to see these issues stack up with disagreement among the circuit courts. And we know that the Supreme Court can't review every case that that it's asked to review, and they have to prioritize those cases. Usually, or one of those ways that they prioritize cases is whether or not there's a split among the circuits, whether there's disagreement among the circuits. So I think, yes, that's true to some degree, that the Supreme Court will let the cases percolate. But in this instance, and we talked about this on a previous show, there have been so many more cases following Bruin than there were following Heller. Mm-hmm. And so those cases have stacked up and percolated much more rapidly than they did after previous cases. So I think we're likely to see the Supreme Court review some of these cases in the near future.
Well, and if I'm remembering right, the Bruin decision, they had oral arguments in November, and the decision came down in June or late June, just before July. It was the very end of their term. So if we're going to have them hear these cases, my guess is we're gonna hear about them taking the cases up sometime this summer. We'll get oral arguments this fall. We'll get a decision just over a year next June. Is my timeline kind of right there?
Yeah, I think so. I think that's basically the timeline we're looking at. It will be interesting to see which cases they take. I don't think they'll take all of them, but I think the cases they take will be instructive with respect to the other issues that are percolating in the circuit courts.
Uh,
For instance, one of the issues that is coming up quite a bit is what period of history do we look to analyze Second Amendment restrictions based on the text, history, and tradition? Do we look to 1791 when the Second Amendment was adopted, or do we look to the Reconstruction era after the 14th Amendment was adopted, when there were concerns about the civil rights of newly freed slaves? So there's that debate and discussion. And I think Mark Smith from the Four Boxes Diner has some great discussion about this, and I tend to agree with him that we should look to 1791 and then look to later history simply for confirmation of what we believe the history to be.
well, and in 1791, everything was legal, and the Reconstruction era, the laws started to come in. And let's just be brutally honest about this: the laws that came out of the Reconstruction era, especially in the South, were just to keep firearms out of the hands of freed slaves.
Yeah, they were. It was very intentional. Those laws were directed toward the newly freed slaves to keep firearms out of their hands. So that's not a good period of history to look to in support of your argument.
Absolutely. I want to skip down a story because actually I put them in the wrong order when I put show notes together here today. But next one is still another legal story. Appeals court weighs constitutionality of the New York concealed carry law. This one off of Ooley and Times Herald. A three-judge panel of the U.S. Second Circuit Court of Appeals is weighing whether New York's Concealed Carry Improvement Act is constitutional. The justices, during a hearing Monday, listened to arguments in 4 related cases concerning the CCIA, including one brought by Niagara Falls pastor Jimmy Hardaway Jr. of Trinity Baptist Church and others. One of the 3 justices hearing arguments suggested whatever constitutional determination they make is likely to be reviewed by the U.S. Supreme Court. We're going to have to make a rule, Justice Gerald F. Lynch said in discussing a challenge to a provision of the CCIA that requires private party owners, in particular businesses, to open to the public to make known whether persons licensed to carry concealed weapons can bring those firearms onto the property. I'm just going to add, I didn't get it in show notes, but from my memory, going back to remembering when I was listening to oral arguments for the Bruin decision, you could read tea leaves when you were listening to those, and we kind of knew it was going to be favorable. We didn't know how favorable. It kind of sounded like it was going to be favorable in those oral arguments. Reading this article the first time this morning, the judge says, so I don't get to decide whether somebody carries into my home, and that it really, this could be a biased writing of the news story. I didn't listen to the oral arguments myself, but it sounds to me like this 3-judge panel of the Second Circuit, it's going to be a tough go there.
Yeah, I think so. And if people recall from our discussion of oral argument during the Bruin case, or if they listen to the oral argument themselves, there was a lot of discussion about sensitive places and what places could be off limits. And I think that's partly what's at issue here. And I think the judge here is right that the Supreme Court will eventually opine on this issue about sensitive places, because, as we know, New York, right after Bruin was decided, implemented this Concealed Carry Improvement Act and basically identified more sensitive places than places where you could carry a firearm. So it was an exhaustive list of places where you could not carry, and I think they were places clearly beyond the bounds of the Second Amendment. And in fact, in the Bruin decision, they only mentioned three places that would have been historically sensitive places: legislative assemblies, polling places, and courthouses. Now, I think that the court ultimately will uphold schools and government buildings as well, but and those are mentioned in the opinion.
Mm-hmm.
But I think these places like New York, New Jersey, and other states that have passed laws with an exhaustive list of sensitive places are going to ultimately get turned down by the Supreme Court with respect to their interpretation of sensitive places.
I want to get a comment in here real quick. Roderick Converse on the Facebook side says, naturally, NYSRPA versus Bruin is not an expansion on the right to keep and bear arms. And he's right, it's a restoration of.
Yeah, that's exactly right. It's a recognition of the right that we've had forever. Because remember, the right to keep and bear arms pre-existed the founding of this country. It pre-existed the Second Amendment. All the Second Amendment does is recognize that right and says, government, you cannot violate, you cannot infringe on this right to keep and bear arms. So Bruin doesn't expand the right in any way. It simply helps recognize that right and restore that right, or at least restore the protections of that right.
I've got one more story I want to cover today, and this is, it comes up from time to time. Alec Baldwin apparently, from various news stories I've heard, this one I do not actually have the link for the story in front of me. Alec Baldwin is apparently not going to be charged in the Rust shooting. But the story I got this morning said, despite a heady day of news about special prosecutors in New Mexico planning to drop criminal charges against Alec Baldwin for his role in the shooting deaths of cinematographer Helena Hutchins on the set of Rust in 2021, the actor and producer may still face charges. The special prosecutors said on Thursday regarding the decision to drop charges. They may be refiled after further investigation. So apparently, and I know this from personal experience, when charges are dropped, when charges are brought, if they're dropped, they can be dropped one of two ways, with or without prejudice. If they're dropped with prejudice, they cannot be brought again. Apparently, when in the process of dropping the charges against Baldwin, they're not dropping them with prejudice.
Yeah, that's right. And your characterization there is exactly correct. I haven't seen the dismissal filing, but it sounds like you're right that they dismissed without prejudice. So it sounds like they can simply refile if through their investigation, they find other evidence supporting the charges. I don't know what that evidence is or what evidence they found or didn't have that they thought they needed to dismiss. I heard there was some, and I don't know if this is reliable, but I heard there was some evidence maybe that the trigger required almost no force to set it off. But I don't know that, and I wouldn't rely on that information. But who knows? So they could refile, but this has been going on for quite some time. And these are new prosecutors. The original prosecutor on the case is no longer on the case, and so we have these special prosecutors now.
Absolutely. Well, we're down towards the bottom of the hour, man. If you would, real quickly, tell us about Forge of Freedom podcast and anything else you want to plug today, man.
Sure. So the Forge of Freedom is a podcast I started at the beginning of the year. I care a lot about our right to keep and bear arms and firearms, but I care about freedom more broadly. And so I started the podcast with the hope of spreading the message of freedom. So I talk about lots of things ranging from philosophy to freedom and personal responsibility. My dad is an attorney as well. His name's Mike Ooley. We just recorded a podcast kind of recapping the NRA annual meeting and that'll come out tomorrow. This Sunday, I'm recording an episode about the question of, were the perpetrators of the Holocaust just following orders, and sort of the psychology behind that. So that'll come out Sunday, but I've got lots of other topics out there: jury nullification, qualified immunity, just about any topic related to freedom. So if that's of interest to you, you can check that out on YouTube, Rumble, and all the most popular podcast streaming platforms.
I got to say, man, excuse me, you bring that up, and immediately that brings up 5 or 6 questions that will wait because we don't have time for them today. But yeah, you just opened a can of worms in my brain. But for example, one, we don't have time to talk, so don't answer. But soldiers don't get the "I was just following orders" exemption. Do police? Do prosecutors? Yeah, where does the line stand on that? So that is going to do it for us today. That's all the time we have. Alex, thanks again for joining us today.
Yeah, thanks for having me, Paul.
We are going to step aside for today. And until next time, everybody, thank you, podcast listeners, for listening. Thank you, viewers, for watching and joining us live. Podcast listeners, if you've got the time, sometime join us 6 p.m. Central Time. Come and join us live. Get your comments in. Until next time, everybody, thank you for watching. Thank you for listening.